Thank you, Mr. President. I've been listening with a great deal of interest as well, and I have to say that the offering from the Honourable Member for Mersey struck a chord with me, and I guess in reading all of the information that's been provided to us in this, the letters coming in from both sides of the argument, the information that I received in a briefing paper from the Anti Discrimination Commission by Georgia Allen, to me, it would help me to understand this, I think, a little more. And I want to read from that paper and from the conclusion of that particular briefing. As shown in this report, while Section 17.1 of the Anti Discrimination Act may be ideologically or politically disproportionate to some, it is not legally disproportionate. It is clear that the amendments would not unduly restrict the freedom of expression or freedom of political communication if the Commissioner and Anti-Discrimination Tribunal continue to apply the essential common law principles of legality and proportionality and the rules from Brigginshaw and Longer. The balance between the freedom of expression and political communication and the right to be protected from prohibited conduct is not skewed in this legislation, as adequate protections from undue restriction are offered to respondents. Now, I just want to read what this paper has to say about the Brigginshaw principle, and it's an interesting section 5 in this report. As anti-discrimination complaints raise civil issues, the appropriate standard of proof is on the balance of probabilities, or, quote, satisfaction on the evidence that the matter found to have occurred is more likely than not to have occurred. That comes from a John Dyson Hayden. Cross on evidence is the reference. The full court of a High Court held in the case of Brigginshaw, however, that in relation to a civil matter, quote, questions of fact vary greatly in nature and in some cases greater care in scrutinising the evidence is proper than in others, and a greater clearness of proof may be properly looked for, unquote. The Brigginshaw approach is based on the principle that a court in a civil action should not lightly find that a party has engaged in wrongdoing if there would be serious consequences for the respondent. Dixon J. explained this in Brigginshaw when he stated, the seriousness of an allegation made, the inherent unlikelihood of an occurrence of a given description, or the gravity of the consequences flowing from a particular finding are considerations which must affect the answer to the question whether the issue has been proved to the reasonable satisfaction of the tribunal. As anti-discrimination legislation is civil legislation, both the Commissioner and the Anti-Discrimination Tribunal must apply the Brigginshaw principle when considering the validity of a complaint. While the Anti-Discrimination Act is not criminal legislation, it is clear that it deals with serious misconduct, with discrimination and prohibited conduct both derogatory to social cohesion and equality. Thus, the objective standard in Section 17.1 is strengthened by the requirement that the Commissioner and the Anti-Discrimination Tribunal must proceed cautiously where a serious allegation has been made or the facts are improbable. The Brigginshaw test is further strengthened by the common law principle of legality, and I could go through that, but I won't. I guess the important thing is that in this, and it's in that conclusion, it may be ideologically or politically disproportionate to some, but it is not legally disproportionate. And I think we have to rely on the fact that they're using these principles when they're, getting to the point as to whether or not a person has a case to answer, I suppose.
While you're on your feet there, though, but my question was about how do you stop frivolous complaints being made about people?
Well, the complaint can be made, but whether or not it actually has, whether or not it stands.
Well, yes, but then you have to defend yourself. A person would have to defend themselves, and I suppose that's what I'm saying. Does this clause mean that you might well find lots of people having to defend themselves?
Order. not across the chamber. The questions to the honourable member on his feet is appropriate.
That's fair enough. Yeah, I mean, I guess you're only. Yeah, I mean, the honourable member from Murchison, I would suggest, is right, because it would have to actually get to the tribunal or get to the commission before you had to actually defend. I mean, under what circumstances are you going to be defending? You know,
still got a worry and concern that's been done.
Oh, well, there may well be worry and concern, but there are worry and concern on all sorts of aspects. And I take what the member for Mersey is saying in terms of, you know, cutting some of these out. I agree entirely with him on that. Irrelevant criminal record. I have a friend who, way back when he was an older teenager, young adult, committed a crime, and indeed he did the time. He's lived with that. He's 60 odd now, and he's lived with that for the rest of his life, because some people, you know, might bring it up. But what you know, that person should not have to live with that stigma for the rest of his life if he's done the time, you know, for the crime. I mean, that it's important that the whole list is incorporated, and I agree entirely with the honourable member from Mersey in that regard.
Through
and or the issue of the medical record. You know, I mean, if someone has AIDS, for instance, you know, they're living with a trauma, and if you like, as it is, without having people use that against them and not have defence under this.
Through the honourable member, if you indulge, 64, rejection of complaints. 1, the Commissioner may reject any complaint if A, in the opinion of the Commissioner, it is trivial, vexatious, misconceived or lacking in substance, or B, the complaint does not relate to discrimination or prohibited conduct, or C, the complainant has commenced proceedings in a commission, court or tribunal in relation to the same events, and that commission, court or tribunal may order remedies similar to those available under this Act, or D, a person other than the complainant has commenced proceedings in a commission, court or tribunal in relation to same subject matter of the complaint, and the Commissioner is satisfied that the subject matter may be equally dealt with by that commission, court or tribunal, or E, in the opinion of the Commissioner, there is a more appropriate remedy that is reasonably available, or F, the subject matter of the complaint has already been adequately dealt with by the Commissioner, a state authority or a Commonwealth statutory authority, or G, in the opinion of the Commissioner, the subject matter of the complaint may be more effectively or conveniently dealt with by a state authority or Commonwealth state authority.
So under that, I mean, it's got to get there first. Thank you, Mr. Chair.